let's just kind of dig right in with sort of what is the Americans with Disabilities Act Title III. So the Americans with Disabilities Act, is a federal civil rights law that covers public accommodations and requires those places of public accommodations to be accessible for individuals with disabilities, whether that's mobility impairments, individuals with visual impairments, blind or low vision individuals, individuals with hearing impairments. And what that means is really since the ADA came into effect, since the effective date of January 16th, 1992, all new construction or any alterations to existing buildings are required to comply with Title III scope and architectural requirements of the ADA. I get a lot of calls about this, and a lot of owners and operators really think that this section of the ADA Title III is only about really structural modifications. For example, how high a light fixture is, or where you need to place certain handicap signs around the property. But it really is a lot more than that. As I said, this is a civil rights law that just expands beyond the brick and mortar structural issues, but also covers policies and procedures on how to ensure that guests with disabilities have equal opportunity to use the services provided by your store or property. As I said, you've got liability not only from owners and operators, but landlords and tenants and franchisors and franchisees, because the ADA provides for joint and several liability. So a lot of owners think, well, I don't have to be liable or responsible for the conduct of my operator. It's the operator who is, responsible for where certain, doors get placed, or where certain furniture is put and circulated, and make sure that there's accessible space. But that's not necessarily true. A lot of our clients address the sharing of liability through a management agreement or some other indemnification provision, which details kind of who's responsible for defense costs, who may be responsible for any subsequent remediation of the property. But everyone should really be aware that both entities can be named in a lawsuit, and both entities can be held jointly liable. So Title III's obligations focus on a couple of things, right? First, you can't use certain eligibility criteria to screen out individuals with disabilities, right? They need to have the same access to your property and retail amenities and outlets that individuals who do not have disabilities have. You must also, as I mentioned, modify your policies and practices and procedures, unless doing so would fundamentally alter the goods and services of what you do. So for example, you need to allow service animals into public spaces of your property, even if you have a no pet policy, because service animals are not considered pets under the law. And that's a relatively easy thing to do without fundamentally altering the goods and services. Another example is requiring auxiliary aids and services for effective communications. So if you're at a restaurant and you may need to provide certain menus in Braille, or you need to be able to have your servers effectively communicate with individuals who have hearing impairments by being able to communicate through writing or other communication methods. If you're a resort or a hotel and you're holding a conference or a meeting at your property, think about what auxiliary aids or even interpreters may need to be available if someone requests an accommodation if they're hearing impaired. And then finally, the traditional removal of barriers to access, right? If you only have stairs walking up into your restaurant, you need to be able to provide a ramp. You need to be able to have accessible bathrooms for individuals with mobility impairments. If you have a swimming pool, you need to have a lift into that swimming pool. So a lot of different barriers to access need to be removed depending on when your property was constructed. And this is really one of the first things you're going to want to ask yourself if you're served with a lawsuit. When was your building constructed? Because facilities constructed before the enactment of the ADA, before January 26, 1992, those facilities are only required to remove barriers if it's quote-unquote readily achievable. Readily achievable is a legal definition that does not require much difficulty or expense. And that is going to vary property by property, because whether something is readily achievable is going to be governed by the various factors such as the cost to remove the barrier, the size of the business, and the business's financial resources. So if you are a single store operator where you only have one store and it's been in existence since the 1980s and you don't have large resources, what might be available for you to modify, for example, your front walkway to include a ramp might be much more expensive than if you were a much larger property that had several properties around the country and much more significant P&L statements and financial resources. So it's really fact-driven determination as to whether a certain element is readily achievable or not. If a removal of barrier is readily achievable, then there's no violation, even if that disabled individual is provided effective access. So that's the other question you want to ask me. You want to ask yourself, well, has that person really been discriminated against, or has a barrier to access been in place where they are unable to access a certain amenity? If they are able to access, the ADA will not be implicated. For newer constructions, however, these are buildings that have been built since January 26, 1992. Those have a different requirement. Those really, the ADA requires you to become much more robust to make sure that you are complying with Title III, because the perspective is the law's been on the books. There's no grandfathering or anything like that unless you're a historical facility. And you need to be able to, the expectation is that you will have built your property up to code, or you will be bringing your property up to code, particularly as you're doing additions or alterations. So facilities that have been built between 1992 and 2012 are required to comply with certain regulations called the 1991 Americans with Disabilities Accessible Guidelines. They're called the ADAGs. They don't carry the force of law because they're just regulations, and they're not necessarily even regulations that have been adopted yet by the Department of Justice, but still they are very strong and given significant weight as to what is required under the law. And then even more recent facilities, more recent alterations must comply with the current ADA standards, which is the 2010 ADA standards, and those came into effect after March 12, 2012. So one of the first things you're going to want to know, and one of the first questions I ask my clients when they are in receipt of a lawsuit is, when was the property built? And if the property was built more than, pre-1992, have there been any changes? Have there been any additions? Have there been any substantial alterations? And when I say alterations, I mean things that require permitting, changing of walls, structural issues, fixing bathrooms, really, again, plumbing issues, not cosmetic changes like recarpeting or repainting or even restriping a parking lot. They need to be much more substantial alterations to trigger these more recent compliance regulations. It's important to know as well that the ADA standards for accessible design that came into effect in 2010 and 2012 added a number of new requirements within places of public accommodation that previously had not been regulated. So places like amusement parks, exercise machines and fitness equipment, swimming pools, spas and saunas, golf facilities and playgrounds. If you are a hotel operator or owner and you are really only focused on your building, but yet you also have these other elements around your facility as well, it's important to know that these areas now are required to be updated, and that there's not a grandfathering or safe harbor provision with respect to these aspects and new aspects of the law. So the other thing that I focus on, as Andrew and I both do, is responding to litigation. And I would say, taking the last 2 years aside, where we've seen the onslaught of website accessibility issues, and Andrew and I will talk about that a little later. traditionally this area of our practice has been on, the common access barriers, really. And a lot of it is things that happen can be done by an individual who doesn't necessarily need to patronize your facility, your restaurant, stay overnight at your hotel. It's what we call the drive-by plaintiffs, who can literally drive in through your parking lot, identify issues with the parking lot, whether it's striping or proper van access, or whether there's accessible entrances around the property. Even come in and just patronize the public areas of the property, buy a coffee at Starbucks, sit in your lobby for a few minutes, take pictures of the lobby restroom, and then leave 30 minutes later. Then we get a lawsuit, and what that might entail is then a full wall-to-wall inspection of the entire property. And so one of the recommendations that we often advise our clients is, if you're not in a position to do a full audit and inspection of your property for ADA compliance, which is really the gold standard, at a very minimum, take a look at these easy issues at the very onset of a litigation, and that might deter a potential plaintiff if they feel that your parking lot, that your front desk area, that your swimming pool, and your other areas that are easily accessible, if those are compliant, they might be dissuaded from pursuing a case any further. So I'm going to touch pretty briefly on some of what these issues are under the 2010 standards. So you've got your parking lot, and you've got to have a certain number of accessible parking spots available with the right handicap signage. You also, though, have to provide accessible parking spaces for vans if it's readily achievable. And in fact, one of every accessible spaces must be van accessible. An accessible parking space must have an access aisle, allowing the wheelchair to get in and out of the vehicle. And sometimes this can be remedied as easily as just restriping your property, your parking lot. It may not require any repavement. It may just be looking at the number of spaces that you have in total, ensuring you have the right number of spaces, both parking and van accessible spots, making sure that the path of travel from that parking space through the access aisle to the sidewalk into the accessible entrance into the property, is compliant with the law, that it's level, and that gets you in at least, and that can really help avoid a lot of the common drive-by plaintiffs who might not even want to necessarily get out of their vehicle to determine if a property is compliant or not. Then once you get past the parking lot, you want to make sure your entrances are accessible. So under the 2010 standards, at least 60% of public entrances must be accessible. So if you only have 2 entrances, both of them need to be accessible for individuals with disabilities. Now, if you have more than that, you can determine which are the most easiest to be accessible. But current law is at least 60%. More than half have to be accessible. And at least one accessible route must be provided to the accessible entrance. So you want to think about, how do people come onto your property? Do they come on from the public street, maybe from a bus stop very close by, and you've got the public sidewalk getting onto your property? How do they get into your property, and what is the accessible path of travel from the public right-of-way into your entrance? As I mentioned earlier, if you have a private parking lot, you really want to make sure that the path of travel has an accessible route from the parking lot to the accessible entrance. For doors that are at your accessible entrance, those must be at least 32 inches wide and have a sufficient maneuvering space for individuals in wheelchairs. We're seeing a lot of litigation right now at accessible entrances with, loading zones, passenger loading zones, to the extent you've got that, and making sure that that area is accessible as well. For those of you on the call that are hotels, as you know, a certain number of your guest rooms, depending on the size of your property, have to have a certain number of rooms with roll-in showers, rooms with hearing impairments. I'm not going to detail specifically this chart, but this is there for your reference. It's a quick and easy chart to let you know what those requirements are depending on the number of guest rooms that you have. And the only other point I would make about the importance of accessible guest rooms is that they need to be dispersed equally around throughout your resort so that they have, rooms with double beds, room with king beds, rooms that have a good view of the ocean, a garden view room as well. If you've got suites or junior suites, you've got some accessible disbursement there as well. For those that have swimming pools, this was a very hot topic of discussion at the 2010 standards became law as to whether you needed a pool lift or other type of fixed entry into your swimming pool. And what the law says is there needs to be accessible means of entry and exit. And for larger pools, there has to be at least two means of entry. One entry has to be either the sloped entry or a pool lift at a fixed location. A lot of hotels and resorts purchased pool lifts that could be moved or removed or stored in a storage closet when not used. The Department of Justice has taken the position that that is not what the law requires. It requires it to be literally fixed into the cement in order for it to be compliant. Fitness centers, as I mentioned, this is also a new area, a new element that was not previously covered by the 1991 ADA standards. And so if you have a fitness center that's available to the public or to your guests, you want to make sure that the fitness equipment has clear floor space that can be maneuvered and is on an accessible path, and that you've got at least certain types of accessible equipment on an accessible route. And then for those of you also in the hospitality industry, your front desk, again, this is an area that's so easy to be watched and observed by an individual with a disability. They don't even have to engage a front desk agent. They can simply observe whether the registration counter has a portion of its counter that is at least 36 inches long and no more than 36 inches high, which allows somebody in a wheelchair to be able to engage in that consumer transaction with the front desk agent without having that higher burden. There is an exemption, a safe harbor exemption, that have kind of auxiliary counters or an equivalent facilitation. If that was in place before March 15th, 2012, you can continue to use that exception unless there's substantial alterations to the front desk area. And as I mentioned, it's not just your brick and mortar and structural barriers, but also training your staff and making sure that your front desk staff and maybe even your bellman staff or any staff at the front desk area, parking area, bellman, valets, they need to be trained on the requirements for communicating with individuals with disabilities, how rooms get reserved, questions about the hotel and resort's accessible features, and we'll get into a little bit about what that means too at the end of the presentation, particularly as it relates to websites. So there are defenses that we encounter often when we litigate these cases to barrier removal. And some of those involve whether the individual has proper constitutional standing. Again, someone who is going to challenge a barrier, it needs to relate to their specific disability. So someone who's in a wheelchair, who's not visually impaired, not blind, really doesn't have standing to challenge whether a guest room signage has a proper braille or whether a restaurant has a braille menu, since that doesn't really relate to their disability. Similarly, women don't really have the opportunity to challenge whether a men's restroom has the right type of grab bars or urinals for purposes of accessibility, since that doesn't relate to that individual's personal characteristics. Other types of defenses that we often see involve construction and manufacturing tolerances, again, which is applied on a case-by-case basis. One example might be, for example, a slope in the concrete path. That allows for a 1% tolerance, or even tolerance in the height of a toilet or dimensions of a toilet. Some courts have recognized up to 1/2 inch with construction tolerances. So as we do our walkthroughs and our inspections and look at measurements. The plaintiff may measure something one way. If we're within that sort of half-inch tolerance, we will use that as a basis not to need to remedy that particular issue. Other defenses include equivalent facilitation in the form of alternative designs and technologies, if that provides greater access, or just general structural impracticability. If we've got something where you've got a structural wall that literally cannot be moved because it would, completely destroy the entire integrity of the rest of the building, that's something that we'll be able to use as a defense. So with that, I'm going to kind of turn the rest of the half of the presentation to talk about website accessibility, because as I mentioned in the very beginning, and Andrew will agree, a large majority of our cases and litigation that we're finding now, and even just questions from our clients, will relate to website accessibility and the Americans with Disabilities Act. And these questions come down really to two main questions. One is, do public accommodations need to make their websites accessible for users with visual, hearing, or physical impairments? And the answer to that question is it's complicated, and I'm going to talk about that. And then the second question is, do public accommodation websites need to provide information regarding various accessibility features of the property? And the answer to that is unequivocally yes, and Andrew will talk about that. With respect to the first question, does the ADA require my business's website to be accessible? There's no current regulation promulgated by the Department of Justice, but the Department of Justice has emphasized that the businesses should be making their websites accessible to the disabled, and they've relied on a set of guidelines called the Web Content Accessibility Guidelines, often known as the WCAG 2.0. And so this is going to address situations where customers with a visual impairment or even a hearing impairment are unable to navigate a website because the site's not compatible with the individual screen access software, such as JAWS, and the customer is unable to make an online transaction, consumer transaction, purchase goods and services, access different areas of the website, or even make an online reservation on the website. And we've got this tension because we've got the DOJ saying we believe in WCAG 2.0, but then we have federal courts that come into play, and they've been all over the map. Courts have really ruled on both sides of this issue, both in favor of places of public accommodation, saying that Title III does not apply to websites, and conversely saying that it does. And what's happening is we're starting to see a trend where courts are finding that websites are places of public accommodation. This is particularly true this year in 2018. The large majority of decisions that have come out in 2018 across the country are finding in favor of the plaintiffs in this regard. There's a handful of a few cases, and these are a little bit of anomalies. There was a recent school board case where they found in favor of the school board. There's been a few cases involving federal credit unions that found in favor of the federal credit unions. That really fell on standing. But it really, for the most part, they are finding in favor of the plaintiff. And in fact, one case that was decided in the Ninth Circuit, in a case against Domino's, that's actually currently being appealed to the Ninth Circuit, and oral arguments were this month. So be aware that even though we don't have clear guidance from the agency that regulates the ADA, the Department of Justice, courts are moving towards that direction, and it's our best practice and our advice to do what you can to get your website made accessible. So some common website accessibility features on a website, think about it, it's individuals with visual impairments. So this is someone who is unable to view pictures or maps or any diagrams on your website if they don't have written descriptions. These are individuals that are using a screen access software program. It's a microphone into their ear that is reading all of the text on a website. And so you need to be able to, they need to be able to see and hear what a picture says or what a map is describing in order for them to understand that image on the website. Same thing with click here links. You know, it's a click here to register. You want to make sure that there's an audio file that they know where to click. And same thing as any kind of, you know, text as an image file as opposed to an HTML. Users with visual impairments. This happens a lot with Netflix and other type of audio-related websites. If you have any video or audio files, you want to make sure that that has captioning on it. Again, for individuals to be able to observe and listen and watch those videos despite their hearing impairments. And then users with physical impairments. If they're unable to navigate a website without using a mouse or a keyboard, they need to be able to, you know, tab through your images or your text or parts of your website without necessarily using a mouse. So some common issues and things you want to think about, and what the WCAG 2.0 encourages as best practices, or these kind of issues. And I talked about it in the previous slide. Thinking about providing text alternatives for non-text content, such as your pictures or your maps. Providing text captions for audio content, for any video or audio files, making sure that you've got captioning. Try to avoid using color as the only means of conveying information, such as, you know, green means go, for individuals who may be colorblind. Try and make all functionality available from the keyboard interface as opposed to requiring the use of a mouse. And then provide a way to pause or slow down your timeout features for individuals who may need a little bit more time navigating or understanding the content on your website. As I mentioned, there's been some recent court splits in 2017, and even, you know, as more recently, as I said, we had Florida who ruled in a verdict to a retailer. It was a grocery store, Winn-Dixie grocery store, because its website was not accessible. That was a case that went right to trial. They had access experts. Very few ADA cases ever go to trial, and it was very unusual that Winn-Dixie decided to take that case all the way to trial. But they did, and the verdict was issued not in their favor. And then, as I mentioned, we have the Domino's Pizza case where the federal court ruled in favor of Domino's and dismissed the case brought by the blind individual. And as I said, that case is up on appeal to the Ninth Circuit and was heard in oral argument. Most California decisions, and Andrew certainly can speak to this more cogently than I can, but most California decisions have followed the ruling that websites must be accessible. So one thing to take away is that if you're not able to make your websites accessible, try and have, at a minimum, a toll-free number that's serviced by live agents who can provide access to guests. It's not, you know, a perfect solution, and it's not going to be a complete defense to liability, but it certainly goes a long way, and I think it helps make a good faith argument to the plaintiff's lawyer that this is a challenging issue, and it's not easy to make websites accessible, but you're willing to try and find other alternative ways to make sure that the customer has an opportunity to get the information. Other things you want to think about, given sort of this regulatory ambiguity over websites, is to proactively test your website's accessibility features. There are a couple of free auditing features that you can look at, and I've listed a couple of them here. Those can give you an idea of where errors might be popping up on your website or where it interferes with content accessibility. If you do that, or if you retain a third-party consultant to do an audit of your website, which I know a number of people do, consider whether to do that through legal counsel, either in-house legal counsel or outside counsel, just so that the engagement of that auditor and consultant can be used to protect privilege. I think one of the things you want to be very mindful of is if you are going to be proactive and try and audit your website, but then you do so and you find that the results are not as you may want them to be, and then you find yourself the defendant of a lawsuit, that audit, if it has not been privileged by outside counsel or in-house counsel, that may be discoverable. So it may be very useful to you to do that through counsel. And once you think about that and look about your, how your websites stand up to an audit, you want to be able to put in a policy and remediation plan. So that's going to involve a timeline for remediating your accessibility issues. It's not an easy and fast fix, but if you say, this is what I'm going to do in the next 6 months, this is what I'm going to do in the next 12 months, that, again, goes a long way in communicating to plaintiffs' lawyers that you're taking this issue seriously. You're not, low-hanging fruit. This is something that is important to the business, and that you should not be a defendant in a long-term lawsuit. And I have effectively been able to settle cases very, very reasonably when I can establish that my clients are working on it and do have a really stringent remediation plan in place. And any remediation plan is going to require, the participation of your C-suite and your executive level participation. You're going to need your IT folks involved. You're going to need your CTO, your CIO, and making sure that, again, from the top, you're holding this issue accountable and making it an important business issue, again, to help fend off litigation. Good idea to identify an accessibility project leader. That could be someone in your IT department and maybe someone you want to bring in as a consultant. We've sometimes brought in consultants from the American Federation from the Blind. And again, that's been a helpful optics perspective to say we've got third-party consultants that are working with our IT team to make sure that our website and other software features are accessible. And then to the extent that you do use third-party providers or vendors or anyone to issue your website or capture your website or update your website, you want to make sure they're aware of what accessibility requirements are and what your expectations are of them. Again, looking through your vendor contracts, indemnification procedures, and really just setting forth what your expectations are for best practices in updating your IT issues. Think about creating a web accessibility policy consistent with WCAG 2.0. That's voluntary. Again, it's not required by law or regulation, but if you've got that on your website, something, again, that can be shown to plaintiffs that you're taking this seriously. And then implementing training and compliance with those policies. And if you don't implement certain features because they're unduly burdensome or they'd alter your website, you want to make sure you've got documentation to back up that claim, because it's a heavy burden to prove a defense that something's unduly burdensome. It kind of comes down to the factors I talked about earlier, primarily financial resources. And so you really want to be able to show that you've gotten multiple estimates from different vendors as to how much it would cost to update or modify your accessibility features, and it's just not something that can be done feasibly. You want to have that documentation to defend against any claim. And then finally, as I mentioned, consider retaining accessibility consultant. We are working with a number of them across the country, both to help audit websites, to identify areas of vulnerability, but also to help update and upgrade websites as appropriate. And those really run the gamut because this has been a huge area of litigation. I'm sure many of you have been contacted by various consultants, and you really want to vet them, make sure they're the right vendor for you and for your project. And again, think about whether you want to do that in conjunction with your legal counsel, because it really can help safeguard against liability going forward. So with that, I'm going to turn it over to Andrew to talk about website accessibility with respect to hotels.
Thank you, Kara. I wanted to backtrack for one moment and just follow up on some of Kara's comments about the website issues in terms of website design. One issue that's coming up in California is there is quite an influx of increase in litigation over website issues. And in my litigation practice right now, I would say the majority of the cases that I'm encountering relate to either auxiliary aids, whether for the hearing impaired or visually impaired, and also additionally website issues, whether it be related to a website features, describing the accessible features for lodging establishments, as well as just general website design issues for, largely for the visually impaired. And so most of the lawsuits we're seeing now regarding website design related to the ability, for example, to use a screen reader and to be able to interpret information that's on the website, those suits are largely, at least in California, being filed against larger businesses. It can be a large hotel chain. It can be a multi-store retail establishment. But for the mom and pops, I haven't been seeing suits. I've been seeing threats of suits. But that could be a subsequent wave. So I just would echo what Kara has said about the need to explore, the cost of enhancing website design, the options available, and seeing there might be some middle ground, at least that would not avoid lawsuits, but would protect you to some degree. And one comment I did want to make was regarding the Domino's Pizza case. That was a really good decision for businesses, finding that there was essentially a due process concern by the defendant. What they argued essentially was that there was insufficient notice of the technical standard that would apply to making a website fully compliant with the ADA, and that's because there has been no clear standard on website design developed or placed into effect by the Department of Justice. And so right now what's happening is we have cases that are brought in California where the Domino's case was a bit of an exception, where they said that because in that case the plaintiff was arguing that the WCAG 2.0, essentially that standard applied, the court found that there was insufficient notice of that standard for it to be applied in that case. However, other cases, the majority of the cases after Domino's in the district courts in California have found that although there is no technical standard such as WCAG that necessarily applies, there is, based on the statement of intent by the Department of Justice and the auxiliary aid standard, as well as the general requirement under the ADA to ensure equal treatment for the disabled, that there is a requirement to ensure website accessibility. So where are we now? We have the Domino's case before the Ninth Circuit. We have no clear guidance. So part of the problem here is that we don't have guidance on which standard applies, but we have a number of courts ruling that there has to be a degree of accessibility. So let's turn to the next issue, which concerns hotel accessibility. And I'll cover this fairly briefly, but there was a regulation that took effect about 2012, applying to lodging establishments, and this lodging standard applies essentially to all lodging establishments that have 5 or more rooms. And there's various different components to this standard, and one very general is the requirement that lodging establishments modify their policies, practices, and procedures to ensure that individuals with disabilities can make reservations for accessible rooms. And they have to do so at the same hours and same manner as individuals who do not need accessible rooms. So what that means is that you need to ensure that guests can reserve accessible rooms by phone, in person, or over the internet, if those are all of the means available to the general public to do so. And then what you need to do is ensure that you hold the accessible rooms and not release them until all rooms of that type have already been reserved and the only remaining room is an accessible room. And then at that point you can release the accessible room to the general public. once you reserve an accessible room upon request, you need to ensure that that guest room is blocked and removed from the reservation system. So it's really important that you have a reservation system, and there are many out there, that will provide this function for you so that you have the accessible rooms blocked out, and then once they are requested, that then they are taken out of the reservation system and made available. There has been quite a bit of litigation over guests that arrive the day of their visit, and they had previously requested an accessible room, and that accessible room is not available, and that can create major issues for you. And then just kind of a tag on here, you need to guarantee that as I mentioned, that the accessible guest room is held for the reserving customer. And lastly, there is a requirement that lodging establishments identify and describe accessible features in enough detail, essentially, so that someone with a disability can determine whether that the hotel or other lodging establishment meets his or her accessible needs. And there has been quite a bit of litigation in recent years over lodging establishments not following the regulatory requirement of blocking out and making available accessible rooms. But what we're finding in just the last year is there's been a significant number of lawsuits, hundreds of them, over the failure to describe accessible features. And that there have been a couple California law firms that have filed over 100 lawsuits. And they're going down from the major hotel chains all the way down to small, single lodging establishments owned by just one business. And so it's very important, if you are a lodging business, that you ensure that you have accessible detail on your website. And just in a nutshell, if your hotel was built after the enactment of the ADA, you're not required to provide as much detail. However, if you are pre-ADA, there is an assumption that you will have greater detail about the accessible features, presumably because there's a greater possibility that you may not be fully accessible. And you also have to have detail about the accessible rooms. And so, as indicated, the last prong is crucial, given the recent increase in litigation in this area. And the reason, or one of the reasons why there is so much litigation in this area, is because you can have a plaintiff that never even visits your property, just goes onto your website, finds a violation, and sues you. So it requires minimal effort, and there is, there are plaintiffs at counsel out there that are essentially extracting easy settlements from properties. And so there's no case law out there that I'm aware of that really gets into the detail of what the accessible features was. There was one case I did litigate that had some detail about it, essentially deferring to the Department of Justice guidelines. And those guidelines indicate, as I mentioned, that if it's a pre-ADA property, there's less detail, or that there is more detail that's required than a property built after the ADA. And then it provides other areas specifically where the Department of Justice assumes that accessible features should be described. Okay, so let's move into some preventive strategies that will apply to all of you. And one issue I did want to mention that Kara touched on first is another area where we're seeing much litigation is around auxiliary aids and services. And so I would say that, in addition to the website cases, I'm seeing most of the litigation right now over auxiliary aids. And part of the reason for that is many properties are kind of off guard since it's a relatively new standard under the ADA and are not prepared for those situations. So, as Kara mentioned, it can be a situation where someone wants a menu that they can't read because of visual disability, and that you would provide, for example, a Braille menu. It's also coming up quite frequently with requests at lodging establishments for some sort of auxiliary aid for a hearing impairment. So it could be someone attending a meeting where they cannot adequately hear what is being said, and they would request some sort of device for assistance with that. And it could also be devices that could be used as audio for telephone use within a guest room at a hotel. But moving to preventive strategies, under the ADA, the remedies are injunctive relief to remove barriers, and that's essentially measures taken to correct deficiencies at the property, which can be in the form of installing a pool lift. It can be modifying a reception counter, improving access to the front of the property. And those are all matters that you would want to negotiate with the opposing counsel and ideally reach a more favorable outcome than initially requested. And there can also be changes to policies and procedures. There's all sorts of reasons to push back on that because of the long-term operational impact that could have on you, ensuring that the property, that the business complies with that change. And you can enter into a settlement either through a consent decree or through a confidential settlement. A consent decree is essentially a court order. It's always preferable to have a confidential settlement that's not available to the general public. And a really significant driving force in this litigation is around attorney's fees and costs. So the plaintiff prevailing in one of these lawsuits can recover all of their attorney's fees, what would be deemed reasonable, through the end of the litigation. And therefore, a strategy that we often employ is an early resolution. Let's get the remediation off the table, try to resolve the case early on if we can, minimize the attorney's fees of the other side, and of course, in doing so, you also would minimize your defense costs. And then, just to add, in California, regarding what remedies are available, there's also damages, and that's a large reason why there is so much litigation in California in this area, because a plaintiff can recover actual damages or statutory damages up to $4,000 per incident without even having to prove that essentially that he or she has been harmed. So in terms of other recommendations, Kara did mention that conducting a review of the property for compliance purposes, and we typically recommend doing that through an engagement by counsel so that you have a privilege that you could assert so that it typically wouldn't be discoverable, something that you would have to provide in a litigation matter to a plaintiff's lawyer. And then, as a practical matter, you look at what's been identified in that compliance review, and that's something that your engineer could do. That's something that an outside access consultant could do, potentially. And then you would look at the violations and develop a punch list. And you could go through that and over time look at what you can correct. And, as Kara also mentioned, there's some really easy fix. And an important consideration is to focus on the items that are most likely to result in litigation. So we find typically parking lots. You have the drive-by plaintiff see that there's a deficiency in the parking lot, never actually even come in and sue you. So you'd want to make sure, to the extent feasible, that you ensure that you have accessible stalls in the parking lot, that you also, if you provide a service and you have a reception counter of some sort, that you have a lowered section for the mobility disabled. And then if you are a lodging establishment, looking at your accessible rooms, do you have the adequate number of accessible rooms with the accessible features? And you also want to look at policies and procedures. Are you training your staff on access issues? I think that's really important, given that you could have an action by one front desk clerk that could be something that would bind you and result in a lawsuit. So train them on access issues. There's a variety of ways to do this through video training or in-person training. Update your policies to reinforce your commitment to accessibility. And then when you are purchasing property or entering into a lease agreement, consider access issues. Oftentimes there are businesses that don't, and then they find that there's a lawsuit, and this is intended expense. And then if you are a business with multiple locations, consider a cohesive plan for addressing access violations company-wide at all of your establishments. So we have some do's and don'ts for litigation to kind of walk you through these issues. If you get sued in one of these access suits, you want to review the complaint, and the first thing you want to determine with your defense counsel is who is the plaintiff and who is the lawyer. There's a clear modus operandi here depending on who the law firm is and who the plaintiff is. All are different. Some are more focused on remediation, that the business corrects deficiencies. Others are more focused on just a quick monetary settlement. Some might drag out the litigations. Others might want an early settlement. And this is all really good to know from the outset of the litigation. And then you'll want to consider conducting an inspection, as we mentioned. You can use your engineering team in-house. You could have an ADA access consultant come on and really have a sense before you're too far into the litigation, what are the potential issues? Because a plaintiff can demand a far-reaching inspection, the plaintiff could expand the litigation far beyond the issues initially identified in the complaint. So it's good to know before you're too far along what are the potential concerns with the property. You also, very importantly, should review contracts that you may have with owners, operators, lessors, and whether they have any obligation to indemnify you, because you might be able to request that they defend you in the lawsuit or at least pay for your counsel or any adverse outcome in the litigation. And then you want, of course, early on want to develop what your defenses are. As Kara also mentioned, you want to know when the property was constructed, since that will be a significant factor in determining what the obligations are and whether you have a readily achievable defense. And other recommendations are, promptly eliminating any barriers. Where there is no colorable defense and it's feasible to do so, you can reduce legal fees. We often like to address the barriers at issue where we have no defense and see if we can address it really early on in the case, even if we can't have the work done then, to at least inform opposing counsel that we're going to complete that work to get that off the table. Don't let them work up that aspect of the case and then seek payment in the form of a settlement or a adverse outcome later in the case. And then, of course, you want to reach out to opposing counsel to explore mediation or a joint inspection. And joint inspection is where you review elements at the property. You don't want to delay this too much. The longer the case goes on, the more money that's at stake with opposing counsel and their attorney's fees. And then consider, various different remedies. You can develop, you could serve an offer of judgment, which is essentially an offer of a monetary payment and a representation that certain work will be done. And if you do it in this format, you can limit the amount of attorney's fees and costs that can be recovered by the other side. In California, we have our own version of this where in most access cases, a judge has the discretion to reduce attorney's fees based on the settlement discussions. So any settlement discussions, I like to have them memorialized in writing so that we can show later on to a judge if the case, unfortunately gets that far, that we've been reasonable, the other side hasn't, and as a result, whatever fees the plaintiff is seeking later in the case, that just isn't reasonable and they should be reduced. And then very importantly is you don't want to be in the scenario where you do not, that you do corrective work after the litigation is done and your contractor does not do the work according to the access standards. And if you are in California, you need to comply both with the ADA standards as well as the California Building Code standards, and they're not always the same. And so recommendation oftentimes is that if you are doing this corrective work, to have an architect or an access consultant reviewing the work, at the beginning and at the end to make sure that it was done correctly per code. And some don'ts. So we don't recommend delaying your investigation. The earlier you can determine what the issues are, the more likely you can navigate through the process and forge an early settlement. We don't recommend litigating undisputed violations. If there is no colorable defense, it can be very disappointing to litigate those issues and find yourself in a situation where you have to concede them and that the other side's seeking increased attorney's fees given the amount of work that has gone into the case. And we don't recommend settling these access suits without consulting with counsel. And there's a variety of reasons. One is you want to have a settlement agreement that's going to protect you long term, and you want to make sure you have a broad enough scope of a release to cover any potential claims with that plaintiff, and then also understand, what are some of the ramifications of the settlement and whether there are other considerations that you should keep in mind. And so, lastly, you really want to look at your other properties. And so if you have other properties with similar issues, look at how you could address those as well. And so we have, unless you have any questions, that is the end of our webinar. And we do have an employer defense blog that we regularly write articles on, and it includes both labor and employment issues as well as ADA access issues. And we provided the link here. And well, thank you all. I don't think there's any questions. Thank you all for joining. And we love to speak and write on these issues. And if you have any follow-up questions that you didn't have an opportunity to ask now, you can certainly reach out to Kara or me with any questions.
Thanks, everybody. And as I mentioned, this is being recorded, and we will be sharing the slides with everybody after the webinar later today or tomorrow. And again, as Andrew mentioned, don't hesitate to reach out with questions, but we appreciate everyone's time and attention and hope that everyone found today's webinar to be useful with some concrete strategies that you can bring back to your company. Thank you. Bye-bye.